rebuttal, if any, would you like to reserve?
I'd like to reserve 5 minutes, Your Honor. Thank you.
Okay, I have made that notation. I have my clock here before me, and hopefully it will work, and I will not be so totally engrossed in your argument that I'll miss the clock. I'll do my best to let you know when you get to 15 minutes. Counsel, you may proceed.
Thank you, Your Honor, and may it please the court. My name is Brian North, and I represent the appellant in this case, Nevada Bedwell, who was the husband in a dissolution of marriage action filed below. The several points of appeal that I'd like to discuss with the court today, but I believe one point will be persuasive and will be controlling over the other substantive dissolution points, which is the issue of the venue transfer. As this court knows from the briefs, this case originally started in Orange County in 2013 when the wife herself filed a verified petition for dissolution of marriage. Now, subsequently to that filing in 2000 and later in 2014, the wife filed a motion to transfer venue to Lee County, which at that time is where she had relocated herself with the children. My client, the dissolution proceedings continued in Orange County for unknown reasons. I was not involved in the case at that time until 2017, when the wife filed an amended motion to transfer venue, again to Lee County, and again citing the same reasons, which was essentially a forum nonconvenience argument in both motions. So after a hearing and an order, the venue was transferred in 2017 to Lee County. Now, in the interim, my client did in fact, and the husband did in fact, move himself to Lee County as well. It's our position, Your Honor, on appeal that, and it was my client's position at the trial court level, that the transfer of venue violated Florida law because he can only be sued in the county where he was domiciled at the time of the case.
Counsel, under your interpretation of the record, what was the date that your client moved to Lee County?
Your Honor, my client moved to Lee County, I believe it was in 2014, 2015, Your Honor. I'm not exactly sure because, again, I was not representing him at that time, and I don't believe that that was really fleshed out in the appellate record too clearly.
Well, counsel, according to the record that we have before us, your client filed an affidavit for financial family affidavit on or about January 31st, 2014, indicating that he is relocating to Fort Myers, Florida. Then in May of the same year, 2014, he filed an amended family law affidavit indicating he had relocated employment to Fort Myers, Florida. And so my concern is under 47.122 Florida statutes, does not the trial court have the authority to transfer venue based on the convenience of the parties and witnesses?
Your Honor, that you are correct under that statute. However, that statute is permissive to the trial court to do that, but it's also restrictive at the same time.
At the time venue was transferred, your client had been living in Lee County for a number of years, isn't that right?
Yes, Your Honor, but that is not the standard under the statute. Under the statute, and I'll speak to two cases, one from this court and one from the first district that really speak to this. The statute says that for the convenience of the parties, a trial court may transfer venue to any other court of record in which it might have been brought. And that phrase at the end of that statute, in which it might have been brought, is the key. This case and the general venue law in itself allows the defendant the right to be sued in the county where he resides or where the cause of action accrues. Now, from the wife's verified petition, we clearly know that the cause of action accrued in Orange County.
I have a silly question while you're on that topic, because what you're telling me, I think, is correct, but that would require a voluntary dismissal and a refile where everybody relocated to. Is that kind of an insane interpretation to an extreme?
In order for a defendant's right to be sued in the county where he resides, yes, Your Honor. There was a counter petition filed, so I don't believe a voluntary dismissal on the petitioner's part would have met that goal, because the counter petition filed by the husband in Orange County would still remain in place.
Well, then you'd have a consolidation issue because he would have filed a counterclaim in a county where the wife didn't reside. So you'd have it. I think you want your cake and eat it too. And I'm not sure where you're going with this venue argument if nobody lives where they lived when this case arose. What would be the point of winning a fair victory like that?
Well, Your Honor, the point is the law is very clear, and as this court found in Vincent v. Vincent, cited at 179 Southern 3rd 366, the law regarding venue and venue transfer, the court is compelled to make these decisions because the law tells them to. And even though neither party resided in Orange County at the time, 4 years into the litigation when venue was ultimately transferred, and just so the court knows, from the final judgment, it's clear that trial was about to be set. A docket sounding had been set in Orange County, and this case was almost going to be over in Orange County before it was transferred to Lee County. But in the Vincent case, Your Honor, this court recognized that what controls is where the defendant resided at the time of filing. Now, Vincent was a little different in that Vincent dealt with a defendant who was seeking to transfer venue from the improper county to what ultimately would be the proper county where he resided. But the court's holding is the same, which is that where the defendant resides at the time the petition for dissolution was filed is the proper venue. And in this case, unlike Vincent, where the cause of action accrued outside the state of Florida, in this case, both the cause of action accrued in Orange County and the defendant resided in Orange County.
And the initial petition was filed there, correct?
Yes, Your Honor.
So then what are we to infer from the legislature's passage of 47-122, where it allows for the transfer of venue for the convenience of the parties and the convenience of the witnesses, where in this case, all the parties, all the children, and it appears like all the witnesses are in Lee County, Florida. Under this interpretation, it would seem to suggest venue couldn't be transferred.
I would argue that is, without the consent of the parties, I would argue that is correct, Your Honor, because of the limitation in the statute that only allows the trial court to transfer for the convenience of the parties to another court of record in which this case might have been brought. So the only options for venue in this case.
What you're saying is if it could only be brought in the commencement of the action, in this case is Orange County, there is no change of venue that is allowed even for the convenience, because you're saying the only place it could be is where it could have been brought originally. And the only place it could have been brought originally was Orange County. So render this statute a nullity?
Well, Your Honor, to read the statute any other way would be to render it a nullity. So I don't believe there are other means by which a case can be transferred with the consent of the parties and other ways. You know, the parties could move before the filing. They could dismiss their cases, as Judge Volante suggested. But the statute says for the convenience of the parties, a case can only be moved to another court where it could have been brought. If venue is only proper, this is a right that belongs to the defendant in any case.
Well, what the statute says is that any court of record, which would be the court in Orange County, may transfer any civil action to any other court of record in which it might have been brought.
Yes, Your Honor.
And divorce cases can be brought in any circuit court. Is that correct?
They can be brought in any
Because of jurisdiction.
Jurisdictionally, yes, Your Honor, but this is not a jurisdiction argument. This is a venue argument. And my client has the right to be sued either in the county where the cause of action accrues or where he resided.
He was sued there. Does he have a right to maintain that position in the event that all the parties relocate to another location?
I believe he does, Your Honor. And
so what you're saying is if he can maintain that, this statute that allows a change of venue which we review under this statute for abuse of discretion, basically has no impact, no legal application, and the trial court could not have transferred venue in accordance with this statute.
Correct, Your Honor. But Your Honor, I would argue that this court should review this de novo as a pure
But
question.
we have a case called Johnson, written by Judge LaRose last year, that says the standard of review for this section of the statute, 47-122, is abuse of discretion. You know,
Yes,
so
Your
if we find that this statute is a correct application of law, at least arguably, we review the trial judge's determination under Judge LaRose's opinion for 3 separate factors, which track what the legislature has said, convenience and those things. So I'm a little concerned that the application you are putting forth is to render this statute passed by the legislature a nullity, and that you can't transfer under this statute.
But Your Honor, if the court's interpretation, as you're stating it now, which would be to allow a trial judge to transfer a venue of a case to any other county in Florida, whether the defendant lives there or not, would render this, even though the original case could not have been brought in that county, would render it a nullity.
Theoretically, I think I would agree with you if the trial court were to say, I'm going to transfer to any case that any circuit court that I wish. The standard of review being an abuse of discretion, there still has to be facts in the record to support this. I note that we don't have a transcript of the hearing, but we do have 3 financial affidavits filed by the husband before the trial court entered an order, one indicating intention to relocate to Fort Myers, and the other 2 indicating that he was there, if I recall correctly. So the trial court would have arguably had those affidavits in its court file, and we're in the same place. I don't live here anymore. The kids don't live here anymore. The wife doesn't live here anymore. The witnesses of the alleged abuse and everything else that was alleged aren't here. Why wouldn't 47-122 apply?
That's what we're at. It does apply, Your Honor, but venue can only be transferred to a county where the case could have been brought. And my client, and Your Honor, if I could just state from the case of McGee v. McGee, which is a 1st District Court of Appeal case cited at 145 Southern 3rd 955, the key issue in that case was a defendant's residence. So they really speak to the residence a little bit more. Your Honor, in that case, the court stated—
I don't want to use up all your time. We're at 12. And I think, you may go ahead with your argument. I don't want to take up 15 minutes of your time on one discussion. I know you have other issues, but you feel free to go wherever you want to go.
Okay.
I'm comfortable that I've got your response, and I'm comfortable that I understand your argument, and I wanted to be sure that I did.
Yes, Your Honor. Just going through the other issues, again, we have the issue here where a successor judge, the new judge in the case, signed a final judgment.
I believe the appellee concurred in your argument and said that issue was erroneous, and the argument about the intermixing of the numbers in the alimony, and that they also conceded error there. So those 2 parts, we have concessions of error. Let me ask you one that I'm concerned about, that you raised in your brief, and that has to do with the health insurance. I believe it was under the 3rd issue you raised. It may have been sub B.
Yes, Your Honor.
As I read the transcript, I did not find a stipulation in the opening that said the parties agreed to keep this in force. Nor did I find any objection by way of a motion for rehearing or anything that alerted the trial court to this issue so that it might be preserved for appellate review. I did note that both parties seem to have the same provision in their submitted orders, but can we get to this if it has not been raised or asked the trial judge to rule upon it? I mean, I'm not sure that I buy the argument that it was stipulated to, but my next question is, can we review it without it being brought to the trial court's attention?
Your Honor, we're making a sufficiency of the evidence argument here that there was insufficient evidence.
So we're looking under the rule, under either family law or civil procedure that says in a non-jury proceeding, we can take a look at the evidence even without an objection.
Without a motion for rehearing or an objection, yes,
Okay.
Your Honor.
I just want to make sure I knew the pathway.
Yes, Your Honor. And if that is the conclusion of my 15 minutes, I would ask to reserve the remainder of my time.
Before you go, let me ask you one more thing. There was a claim in the briefing about $138,000 of indebtedness. I think it's your fifth issue. It
Yes.
came up during the course of the trial at trial page 58. And I went back into the final judgment and found that the camper was listed. I don't know whether the boat was listed, but there was an automobile that was listed. And I was trying to get a handle on where this 138,000 comes from. It looks like it's a little bit pulled out of the air, but it also looks like some of the components that were taken into account by the judge are part of that 138,000, because that number doesn't appear in the final judgment as I could find.
Yes, Your Honor, that number does not appear in the final judgment. And again, I don't believe you're going to find a clear explanation for it in the record for what the 138.
Well, that's what I want is a clear explanation, because you've asked to reverse because it wasn't taken into account. And I'm asking you to clarify for a clear explanation as to why we should do that or why we should not do that.
Yes, Your Honor. The court found that the husband left with virtually no marital debt, in about $2,800 in debt, plus the mortgage on the home. Let's see, let me find that. He included a loan for the part. He incurred a loan for the parties for the debt on the party's home, but otherwise leaves with only $2,800 in debt compared to the wife's significant debt. I'm looking at the record page 1578, Your Honor.
I'm not sure where that statement comes from, because when I look at page 3 of the final judgment, the debt on the camper and the debt on the Ford are taken into account. That's about $61,000 right there.
Yes, Your Honor, and those are non-marital debts that were distributed to the husband. Later in the final judgment on the record, page 1578, the court only recognized him as having a debt for the party's home and about $2,800 in debt compared to the wife's significant debt. That's our argument, is that $138,000 is a separate amount which was never accounted for, which has to be paid back in 5 years.
Okay.
That is the bankruptcy debt that the court never gave him credit for in the equitable distribution or in the consideration of his ability to pay out.
Okay. Thank you.
Thank you, counsel.
Thank you.
Okay. Stop. Attorney Perry, the floor is yours. You may begin.
Good morning, Your Honors. May it please the court. My name is Allison Perry, and I represent the appellee, the former wife in this action, Michelle Bedwell. I'd first like to say that the only issue that the wife conceded in this case, we did not concede anything about alimony. We conceded, Judge Vellante, I believe, said that, or Casanueva said.
I did. I indicated, my reading said that there was 2 issues that seemed to have a concession, that the original judge should have signed it, and that the amount of money awarded needed to be differentiated between, I think, child support and alimony in issue 4.
Oh, okay. Yes.
I'm sorry if I did not speak clearly. Those were the 2
Okay.
concessions I understood. And if I misspoke, I apologize, but those are the 2.
I just heard a concession on alimony.
No,
and
only division and, the assignment. Yes, that's it. I'm sorry if I caused you any consternation.
So those are the 2 issues that we have conceded that there was, error or an abuse of discretion. Importantly, both the husband and wife's proposed final judgment required the husband to maintain the children's health and dental insurance as long as they are eligible under the husband's policy. So the husband presented the court. He said, here, this is what I want you to sign in as the final judgment. I want you to require me to maintain the children's health and dental insurance as long as I can do it. That can be found at 1254 and 1269 of the record. So I don't understand how a judge can be abusing his discretion or commit error if he's doing exactly what the husband requested him to do, which was require him to maintain health coverage and dental coverage on the children as long as he could on his policy. So that's, if that was an error, it was an invited error on the husband's part.
Can you have an invited error after the proceeding has concluded? Usually the invited error comes in situations, or often I should say, Judge, you can admit this evidence, or you allow us to amend the pleadings on the eve of trial, or something that comes in contextually with the proceedings. The final judgments are submitted to the trial court after both parties have rested. Can you invite the error through a submission like that?
I believe that's exactly what happened in this case, Your Honor.
That's why I'm asking. I want to be sure.
Yeah, yes. I mean, the judge could not be any more clear. Tell me what you want the final judgment to say. And the husband and wife both presented him with the exact same provision in this aspect, or said, you know, importantly, we want the husband to maintain the children's health and dental insurance as long as they are eligible under the husband's policy. Now, remember, there were many things settled there that had to do with the children prior to the individuals going to court on the case. The court was just to decide alimony and equitable distribution. And then child support was going to fall determining how much alimony the wife got, what she was awarded. So all these other issues, including the children's health coverage, had been they negotiated what they wanted. And then they presented the court with, hey, this is what we want. We want the husband to be required to cover the children's medical care until they can no longer be on his policy. So that's an important, especially in this day and age, that's an important fact that the wife negotiated for the children, and she bargained for it.
Well,
and
if it was this important, why was it not clearly reflected in our record, either by a stipulation of the parties orally or in writing? Because as I read the transcript of the beginning of the trial, and I'm going to go back and read it again in case I misread it, I didn't see a clear statement of that this was stipulated to.
Well, because it didn't seem to be at issue. It seemed like it was agreed upon. They both presented the exact same. There was a meeting of the mind. They both have the exact same provision. After
the trial submission, your argument is confirms that it was intended to be in the submission to the court at the beginning of the trial, and what the issues were identified for trial.
Yes, this just wasn't an issue. It was a non-issue. It, you know, later when I don't know if it's because an appellate attorney took up the case and said, oh, this is an issue we can appeal because you're not supposed to have coverage past a certain age or when they get majority, because that generally is something that can be appealed, but not if you agree to it, not if you ask the court to charge you with that responsibility, which is exactly what the husband did. He asked to be charged with that responsibility, and the court signed what he wanted signed. So I do not see how a litigant can say that is an error on the judge's part when the judge signed exactly what the litigant asked him to sign. That is just not an abuse of discretion to sign what you're asked to sign. Hold me to these responsibilities, Your Honor. Okay, I will. Now I'm going to complain about it. No, that's not how our judicial system works.
Don't forget venue was a lead argument. That was, you've done the
Well,
last
I believe y'all understand the venue argument completely. 47.122 Florida statute is there for exactly the reasons when everybody, all the witnesses and the litigants move out of a venue area.
Well,
that they
what's
can
your take on why he's objecting? Is it a strict interpretation of the statute, or what's
it's because he wants a second bite at the apple.
After
he did not like the way things turned out, and he wants to do it again. You know, you've got to remember, this is a litigant who made the wife go through a complete final hearing saying, the bankruptcy court has nothing to do with it. You need to go forward. You need to go forward. You need to go forward. And then as soon as they went forward, they said, oh, no, you can't go forward because we have a bankruptcy, because he didn't like the results of the final judgment.
All right.
So the final judgment,
Well, I was just wondering if there was a legal argument other than what he made, if there's something I missed. But I got you. You don't have to keep going.
no, I believe y'all have the venue argument under control, and I don't need to add to that unless you have any questions for me.
While you're on the topic of the bankruptcy, can you explain to me why the court didn't address the $138,000 that was claimed indebtedness in the bankruptcy?
I believe
it doesn't appear anywhere in the final judgment that I could find.
is
None of our individual debt was included in the equitable distribution.
none of the individual debt was included in equitable distribution because why?
He bought the condo. That was the main majority of the equitable distribution.
Oh, because the main debt was actually was the condominium that was purchased, which ended up being marital in nature. So I don't quite understand. So the judge, I don't know.
Well, the debts that were in the bankruptcy petition, and I'll have to apologize, I don't remember looking at it. They would be discharged as to him if they were his own debts. Is that correct?
Yes, Your Honor.
All right. So if they're not her assets and he's got a discharge from bankruptcy, that means the debts exist, but the creditor can't enforce them. Is that right?
Yes.
So that means he's protected. And
Yes.
I'm not sure, but if there are joint debts, that does present a problem because she didn't go through bankruptcy, did she?
No, she did not. And
Which would mean she is still liable for them, and those debts, if they were, might have to be ascertained. I think I'll go ahead and take another look at that as well.
I don't believe there were
What
any.
he said in the trial, what he said in the trial is that he filed under Chapter 7, but that it looked like it was going to get converted to a Chapter 13, and he was going to have to pay back that money. And so that was argued in the context of ability to pay alimony. And what he's saying is that he was going to owe another $138,000 that the court didn't take into account, and that goes to his ability to pay. And I don't know whether it does or it doesn't, but it seems to me, I was surprised it wasn't addressed.
Well, the court was aware of his bankruptcy and was also aware of the fact that the majority of the debts that the husband claimed were secured debts. Like his car was valued at, I think, $38,000, but it was, he owed like $38,000, but it was valued at $36,000. The camper was valued at $20,000, but he owed $23,000. So he had physical possession of assets that were associated with these debts. They weren't unsecured debts.
So your argument is either he's going to lose them through some sort of court proceeding, or he's, for whatever reason, he's not going to have to pay that money.
Right. Well,
they're secured.
Correct. Another factor is he was going to go Chapter 7, and then he said he was going to go Chapter 13. And he converted it 9 months into after the final judgment. So it's been converted. But let me see what else we've got here. I do think there is a problem with the successor judge signing the final judgment when the successor judge had not heard the case, but the resolution would just be for the judge to sign, for it to be sent back for the judge to sign instead of having a whole new trial.
The good news would be that Judge Hayes has not retired, so we could actually send that back.
Yes. And
so many of my peers down the 20th Circuit have retired, but Judge Hayes is still on the bench.
Yes, so we would need to do that. Let me see if there's anything else. Now, do you have any other questions for me?
I don't see any from the panel, Attorney Perry.
Okay, and I also just request that you award the wife her appellate attorney fees for this matter. She's filed a request. In the last action, y'all tentatively awarded her appellate fees.
Okay.
So that's all I have.
Okay, thank you, counsel.
Thank you.
Okay.
All right, stop the clock. Clear the clock. Mr. North, I'm going to give you a little extra time since we have used a great big portion of your front, so at least you have 4 minutes remaining rather than what you would have had.
Thank you, Your Honor. Your Honor, I would like to just touch on again the fact that the statute, the venue transfer statute, does not provide an additional clause, 47.122. Venue transfer statute does not say that venue can be transferred for the convenience of the parties or the witnesses to another court in which it might have been brought, or to another court if the parties no longer live in the original court. And here again, Your Honor, I'd really request that you look at the case of McGee from the first DCA, which cites a second DCA case, which was Tyndall v. Smith. And the citation is in McGee, which I've provided to the court already. But the court in McGee recognized that the limitation to transfer to any other court of record in which it might have been brought in section 47.122 means that any transfer is limited to a county that could have been a proper venue initially. That court goes on to say a court cannot transfer venue for the convenience of parties or witnesses or in the interest of justice to a forum that would not have been appropriate for the filing of the complaint or the petition in the first place. Those two readings from McGee v. McGee in the first DCA are clearly in line with the statute, which permits a venue transfer, but only to a county where the case could have been brought. So we would argue that the fact that the husband as a defendant subsequently moved after filing is of no import, because what matters is where was he living on October 23rd, 2013. Now, to the other issues, Your Honor, briefly, as far as the issue of transferring venue back, I believe there is in Vincent and also in McGee, the court recognizes the exception to the statute, which ordinarily says the court cannot transfer venue back to the original county. That is permitted under those two cases when venue was transferred improperly or when there's no other venue to go to. Regarding the $138,000, Your Honor, the court is right that that was converted to a Chapter 13. That $138,000 is a 5-year payment plan under Chapter 13. And just doing simple math, that's over $2,000 a month that my client would be required to pay back over the course of the 5-year plan to get to completion of the 5-year plan. And over $2,000 a month is what the wife claimed on her financial affidavit for her payments to creditors each month. And if the court looks at her payments to creditors, those payments to creditors are almost exactly in line with her monthly deficit, which was just over $2,100. So our argument here on the alimony is that the court, by not considering or taking into account that Chapter 13 debt, does not give him the same protection that it gives the wife, which is the ability to pay a significant amount of debt each month. The same comes through with the, just briefly on the equitable distribution. My client was charged $20,000 for dissipating a marital asset, which was his daughter's wedding. The court made no finding of misconduct. I believe every DCA in the state of Florida is very clear that a finding of misconduct is required to charge somebody with a dissipation. I don't believe that that evidence was even presented. I think the evidence, the record only shows that the wife disagreed, didn't agree with how he spent $20,000 on his daughter's wedding. We would ask that that be removed as a dissipation, and I don't think the evidence supports it being in there. Lastly, Your Honor, another big point the court did was it included an entire Advanta IRA, which my client opened 4 years after filing, as a marital asset, all because he rolled $20,000 into that IRA from a marital account into that non-marital account several years after filing. Your Honor, we know the value of a marital asset, and marital assets are identified as of filing. We know what the value of the marital IRA is. Interestingly, the court doesn't tell us exactly which one it is, but we know what that value was at the time of filing. The fact that my client rolled it into a non-marital IRA that he didn't open until 4 years after filing does not make that entire non-marital IRA a marital asset. So that too, we believe should be reversed as part of the equitable distribution.
Thank you. I think I need to let you know that your time has indeed expired.
Thank you, Your Honor.
We thank you both.
Thank you, counsel.